Materia Toure.
Thank you very much, Mr Speaker. I just want to address the limitation bill on behalf of my colleague Kennedy Graham. The purpose of this bill is to encourage claimants to make claims for monetary or other relief without undue delay by providing defendants with defences to stale claims. The bill would repeal and replace the Limitation Act of 1950, and it's intended to implement the Law Commission's recommendation to replace the current Act with a modern regime. Such a regime would encourage claimants to make claims without undue delay and protect defendants from the unjust pursuit of stale claims. In essence, sir, the three principal changes are envisaged in this bill. The bill would clarify claims affected by limitation provisions. It would clarify the commencement of limitation periods and any exceptions or modifications, and it would address the unfairness that under the current law a limitation period may end before a claimant even knows that something is wrong. Now, the Green Party supports the broad thrust of this bill and will vote for it. There are many initiatives in it that will improve matters. We agree with the recommendations of the committee pertaining to clarifying several definition points, especially extending the definition of the disputes tribunal, defining the terms trust and trustee, and clarifying the date for filing of a claim. More importantly, perhaps, sir, we support the committee's recommendation pertaining to the claims filed under the Bill of Rights Act. Clause 11 defined a money claim as a claim for monetary relief at common law, in equity or under any enactment. That would have included a claim for monetary relief in respect of a breach of the Bill of Rights Act. The committee was concerned that the bill would apply a limitation period to claims for monetary relief for a breach of the Rights Act. Such claims, if time-barred, should be subject to discretion. Inclusion of such rights claims in the new limitation regime reflects the recommendations of the Law Commission. It is consistent with international human rights law. A reasonable limitation period needs to apply to such claims. Defendants need certainty whether their actions might be challengeable, and so we are pleased with the recommendation on that matter. There is also the issue of late knowledge. There are certain legal complications to this, but it was clear that if fraudulent action by another party was one reason a claim acquired late knowledge, that this should be included as a qualifying factor. The main point of debate in committee concerned monetary claims filed after the applicable period. There was a range of views over the merit of the long stop period as defined in clause 10.3b. There were suggestions that the 15-year period should be reduced to align it with the 10 years prescribed in the Building Act. The Law Commission concluded after much deliberation that a 15-year long stop period struck the appropriate balance between justice for claimants and certainty for defendants. The argument for retaining the 10-year period for defective building claims was the complexity caused by the number of parties that might be involved and by the length of time during which memory of events becomes less reliable. But the Green Party shares the view of Labour that these issues are similar for other causes of action. There is no good reason, in our view, for a shorter long stop limitation period for building cases. If it is an odd jurisprudence that would limit legal redress to the subjectivity of personal memory faculties, the same long stop period is more appropriate. So, Mr Speaker, just a short call. The Green Party is satisfied that this bill will improve the law as it relates to the complex area of limitation on claims. We are happy to support it and look forward to its further progress through the House.